Sponsored by the Illinois State Bar Association. My name is Marty Dolan. I'll be your host for tonight's program. And today we're dealing with the very serious topic of dealing with foreclosures. We have three attorneys who deal with this area of just troubled times and dealing with real estate issues. Let me start to my far left with Samuel Levine. He is a partner in the real estate and litigation group of Arnstein and Lair in Chicago, where he focuses his practice in real estate litigation, including foreclosure law. And he is a member of the Illinois State Bar Association Real Estate Section in Commercial Banking. Welcome to the program.
Thank you.
And to my right is Erica Crone-Minchella. Erica has practiced law in the greater Chicago area for almost 30 years. Her expertise spans the spectrum of distressed property issues, short sale transactions, and counseling our clients in reestablishing their credit, becoming debt-free and mortgage-free. She is a leader in the North Shore real estate area. She is also the former North Suburban Bar Director and President of the Skokie Chamber of Commerce. Welcome to the show, Erica.
Thank you.
And last but not least, to my immediate right is Stephen Bashaw. He has practiced in the area of real estate litigation, appellate practice, and foreclosures for over 33 years. He is the past chair of the Illinois State Bar Association Real Estate Section Council, and he is the author on the topic and a frequent speaker on the topic of real estate and foreclosure. He is the director of the Illinois Real Estate Lawyers Association, and he has recently won a pro bono award for assisting active military in foreclosures. Welcome to the program, Steve.
Thank you, Marty.
So, as I said in the beginning of the program, you know, foreclosures and dealing with foreclosures is a very serious topic that many people are facing now, or we know somebody who's dealing with the issue. Sources say that 1 in 20 homes is either in foreclosure or about to go into foreclosure. So this continues to be a very deep, serious conflict in our economy right now and the state of where we're at. So I'm going to turn to you, Steve. You've been practicing this area for 33 years. How do we help people? What do we do when somebody gets that notice that they're in default?
Well, Marty, I think the first and most important thing is that, you know, people really need to take a proactive approach to it. They need to take a deep breath. They need not to get into denial, as our teenage children would say, right? And, you know, they need to recognize that better people than you and I are in this situation today. And, you know, if you can look this beast in the eye and understand it, because it is understandable, it's the uncertainty that drives people a little bit off on it. It can be dealt with. You need some help. You need somebody to walk you through it a little bit, but it's not the worst thing that ever happened.
Samuel?
You have to come up with an objective. You have to come up with a plan as to what you want to do, because there are things that can be done depending upon the circumstances. Perhaps you can speak to the lender and work out a modification of the loan, or and if you just feel you can't handle it, perhaps a deed in lieu, or you can fight it. But you got to come up with some sort of objective and some sort of plan.
Erica?
And probably the best idea is to make sure you're not doing it alone. Look for professionals who know what they're doing, certified HUD counselors, attorneys, people who know what is going on with this process, know how to walk you through it so that you know what your time frames are, you know what your options are, you know what's the best way for you and your family to approach the problem, not what your next door neighbor is going to do.
And I'm going to get into some of the specifics here on, you know, what needs to be done with this game plan and how to approach it. It would seem to me like a big issue, like you just kind of mentioned, Steve, is, you know, this whole issue of pride, and you know, now everything is falling apart and,
sure.
and this type of thing. And I would have sensed that that would be the immediate reaction to people.
It is, and I think Samuel said something very important. That is, you have to have a plan. And what I think people need to do when they're formulating that plan is to look at two issues really hard, and it's hard, right? These are very factual issues, not about home, not about hearth. You have to look about whether or not you have equity. Is there value in this property over and above the debt that's owed on it? If you don't have equity, there's a number of alternatives that won't fit into your plan, like refinancing. And then you need to look at something else, and that is what we call utility, the value of being able to use something. If your monthly mortgage payment is $3,000 and the equivalent home could be rented for $2,000, then you see there isn't any utility in the property. You take that and combine that with no equity, and your paths are much more limited, and what you have to do becomes, I think, much more clear.
So before we get into the game plan that you mentioned, what I think is a good thing, and it's a good thing to do with anything you do in life, is to formulate a plan. I would think that a lot of people have to be aware of scams that might be going on, or companies out there representing themselves to be experts in foreclosures and things. So before that game plan begins and you get this notice that you're going into foreclosure, or at least you become aware of the fact, for whatever reason you got there, you got to eliminate what's reality from what's not reality. Erica,
Well,
and you've seen it.
Right. A lot of that has to do with doing your due diligence. There's so much information on the internet now. If you are looking at someone who you want to do business with, check them out on the internet. Check them with the Attorney Registration Disciplinary Commission. Check with the Better Business Bureau. Whatever agency might be supervising that individual, you check to see whether that's somebody who someone else had a complaint about, or whether there are no complaints about them and you feel that there's some reason why you can trust them.
You got to be aware of direct solicitations, and don't be afraid to contact others. Don't be afraid to contact local bar associations, but be careful, because there are people out there that can make your situation a lot worse.
Give me an example.
Mostly by taking your money.
Now, how would that, give me an example how that
two very
happens.
simple examples, both of which Erica and Samuel have alluded to. You'll probably get contacted by, quote, forensic auditors who are going to tell you, and they use all of these buzzwords from the internet, about how the chain of title, or where's the note, or, do they have standing? And they'll want $3,500 for that. Well, all the information that a forensic audit is going to get you can be gotten through discovery in a foreclosure case. It's right there. You don't have to spend that money for it. The other key, Marty, to look for is when you get a solicitation from a company in Texas and you're in Illinois. Texas law has nothing to do with Illinois law when it comes to foreclosure. It's completely different. They don't even have judicial foreclosures. So deal with local people, deal with people who are recommended HUD counselors, and when somebody says to you, you need to write me a check with a comma in it, think about it for a second, because what are they going to give you for that money?
Well, plus, I mean, if you could pay that money for that type of service,
you wouldn't be where you are.
You wouldn't be where you are.
That's right.
So let's talk about get into the game plan issues, and what do you do pre-foreclosure, or even if the foreclosure is to occur. And there's several options, from what I understand, that could happen. So let's just kind of start there and see, where it goes. So what are some options that people have, when there's pre-foreclosure?
Well, the one that comes up most often, I think, that I hear about is whether or not you should get involved with a short sale or a deed in lieu of foreclosure. Both of these are where you give up the property, and basically, I think there's a lot of misapprehension and miscommunication about those. I'm not really in favor of short sales, because I think it's only the transactional people, the commission people, who get anything from a short sale. Although Erica does some work on
I
that.
disagree with you. I think that there can be some real advantages to a short sale, that you are not getting a foreclosure on your record, on your credit record. If you are negotiating the short sale, if the short sale can be negotiated properly, there won't be any deficiency, there won't be any money owed to the lenders. You have certainty as to when you're going to need to move. There can be some real advantages. I agree that the providers are getting the bulk of the funds, but there are other intrinsic value to doing a short sale.
Well, two things.
Go ahead, Sandy.
First of all, with regard to a short sale, it's important that you do your best to try and avoid personal liability, because even though you give back the property to the lender, you still may be on the hook for a deficiency, the difference between the amount that's owed and the value of the short sale. Now, the other thing to keep in mind with the deed in lieu of foreclosure and perhaps a short sale is that there may be tax consequences, so you need to talk to your tax professional.
So it sounds like you need the cooperation in a short sale of the lender. I mean,
that's the real problem, Marty. The real problem is getting the cooperation of those lenders. Try to get some of those lenders to answer the phone or to answer the phone with the same person once in a row. It just doesn't happen. And a lot of times they let go sub silentio these big issues like, are they going to waive the deficiency? And are you going to get a 1099 so that you have a tax problem anyhow? Do you have to surrender possession of the property now rather than 7, 8, or 12 months from now?
And it seems like short sale is it's a good buzzword these days. You hear it, I don't know, I hear it on the radio or people discussing it when they're in these issues. But you really need a good counselor. You need somebody local to be really looking at the back end of that deal, which would be, even though the short sale happens, am I still going to be released of all obligation under the mortgage?
You need to look at the front end of the deal too. You need to look at what your client needs, what that individual needs in terms of how they're going to move their life forward. And if a short sale may be a good alternative for them, it may be that they need to look at their mortgage and see whether there are defenses to the mortgage before they make a decision that a short sale is appropriate.
That's a wonderful thing that she just said, though, about how our clients are going to look for their life to go forward. Too many times they're looking in the rearview mirror and they see the truck coming. But this is really a time with opportunity.
Let me cut you off there, but I want to get back to this issue and the game plan and what we have to tell people on this topic. This is Illinois Law, sponsored by the Illinois State Bar Association. We'll be back in a moment.
Bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault! Never! Mister!
Over and over.
Come on! It's harder! Leave me alone! Shut up! Out!
Time and again.
No! Drive me nuts! Shut up! You're the dumbest
Generation after generation.
I hate you! I hate you too!
Isn't it time we stop the cycle? Now.
I hate you!
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to Illinois Law, sponsored by the Illinois State Bar Association. My name is Marty Dolan, I'm your host, and today we're talking about dealing with foreclosures and a very serious topic of when people get faced with the prospect of a loan default or not being able to pay their mortgage. Before the break, we were talking about this game plan that people need to focus on when they either become aware of a notice of a default in the loan or they know that foreclosures are imminent. And we talked about a little bit of the options that are there, and short sales was one topic that we talked about. But a serious issue in this game plan prospect is how much time do I have? What is the timing of all this when I know now I'm faced with this situation? Samuel, let me start with you.
Well, the minimum amount, subject to certain exceptions, is 7 months between when the last of the owners is served with the summons and the end of the redemption period. By the end of the redemption period is the opportunity to pay back the amount that the court finds is due. And then after the end of the redemption period, there's a sale, there's a confirmation, And then, if necessary, the sheriff can evict, and even after the confirmation of the sale, you get 30 days to stay. So, you know, you're probably talking at a minimum of 9, 10 months. But the thing to realize, and so many borrowers don't realize that time goes by very quickly.
So you have to have this game plan in place. And
Right.
it's not as if when you get the notice, you got to pack your bags and move out the next day,
Right.
which I think is that panic.
There are many clients that will talk to me and say, when is the sheriff going to be at my door?
Right.
And you know, they need to understand that there is a process in Illinois, and I think that's one of the advantages of going through a foreclosure in Illinois, is that there is a process that has to be followed, and the sheriff isn't showing up there at their door unless they've paid absolutely no attention to what that process is and where they're at in that process.
There's another component to the time period that Samuel mentioned, the 7 months from the day you're served with a summons. It's 7 months from the day you're served with a summons for residential real estate, or 90 days from the date the judgment is entered, whichever is longer. So once the case has been going on for 4 months, if the judgment isn't been entered, and this is where it really pays to have good counsel involved who knows, you know, what are the procedures, what's due process. That's all that the defense lawyers really want, right? We don't want a magic bullet. We don't want to make the mortgage disappear, but our clients are entitled to due process. And due process these days can take quite a bit longer, and that 7 months, 9 months, we all three of us have cases that have been going on for 2 and 3 years.
And we're certainly not advocating, you know, when you get this notice, just do nothing and sit in your house for 7 to 9 months, okay? We are going back to this issue of you have to take a step back,
Be proactive.
formulate a game plan.
Right.
One of the analyses you have to go through too is to determine whether the steps you've taken before you went into foreclosure are not being successful, and possibly a mediation program. In Cook County and Will County, there are mediation programs that can help you work through the solutions that you might not have been able to get through on your own prior to the foreclosure being filed.
It's important, if you've tried mediation for a loan modification and it hasn't worked, mostly because of communication, that you're aware of the fact that in Cook County you can get involved in, you can actually opt into the loan modification process through mediation in the courts. In Will County, for instance, it's mandatory. Every case goes through it, every residential case. So if the Bank of America didn't return your calls, or if some other lender didn't return your calls, or you think that you meet all the qualifications, and for some reason your documentation didn't get reviewed properly, there is a due process for that, at least in these 2 counties.
So this is after you would get served with the summons,
Yeah.
that you were actually sued, you know, with foreclosure documents.
But as Erica says, it follows that time when before foreclosure you tried to get a loan modification, it didn't work. But a loan modification, too, we need to say this, isn't a panacea.
Right.
We have people who come, I have people who come to see me, and they've got a house that's worth X, and if they take a loan modification, they're going to pay 2 times X for it. And sometimes when you look at the equities and the utilities, it's just not worth it.
So,
I refer to it as kicking the can down the road. The problem is here now, and all you're doing is delaying an ultimate resolution.
and again, it sounds like another one of these things where it looks attractive up front, but when you really peel away what it is, it may not be the best thing.
Maybe the second bailout. The banks got bailed out by the government the first time, and each one of us individually may bail them out of a very bad mortgage by paying a loan modification. And that's you hear about these trial modification plans, the same thing.
So it sounds like that's a limited option and maybe not advisable as far as loan modification. It really depends on the circumstances.
Each case, right?
Each case is different.
What about other things that can be done in this game plan, whether it's accepting the foreclosure? I mean, is that Is that a possibility? Is that something that
Absolutely.
we should think
Yeah.
about?
One of the things a defendant can do is enter into a consent foreclosure. A consent foreclosure concludes the case but assures that they will not be charged with a deficiency. There won't be any more money that they owe on that case. They have certainty as to when the case is going to conclude. They have certainty that they won't have any further liability. Everyone gets to move on.
There's another area that needs to be explored, and that is there are times when there are legitimate defenses to a foreclosure. And in today's world, with all these banks merging, with computerized records, there are a number of ways to fight a foreclosure. And one way is the amount due. There are so many times when I've represented a borrower and the lender is not able to prove the amount due and therefore is not able to foreclose, which is another reason why it makes sense to find a lawyer. And I know Steve and Erica have had situations with other defenses to foreclosures.
But basically, that's where we go back to that same concept. That, you know, just because you didn't make your mortgage payment doesn't mean you're not entitled to due process.
Right.
The lender has to prove that they have the right to foreclose your mortgage. This is that argument of standing you here. They have to prove that the person who signed the affidavit has actual knowledge. That's that robo-signing you hear. But lay people have to be careful with that because there's a process and there's a procedure and you have to follow the Code of Civil Procedure.
And it sounds like, you know, what you're saying is sometimes the banks aren't always right.
The banks aren't always right. And the other thing, too, is when you represent the borrower, you're trying to create an objective. And in order to do that, once you create that objective, you put more pressure on the lender when you have a legitimate defense that you're able to achieve a goal, perhaps a modification, perhaps a short sale on a better term. So that's really good. You got to create that environment. That's the word I was looking for. You got to create an environment whereby your client, whereby the borrower can achieve an objective.
And, you know, again, taking looking at the picture as a whole, you know you're going into foreclosure, you get the notice, whatever, you're taking that step back first. You're realizing I'm not alone, this is not the end, I can deal with this.
Right.
Coming up with this game plan. One of it is, you know, and the most important thing is consulting a proper professional. It has to be done because it seems like you're at such a disadvantage with the banks, I mean, from what you're all telling me.
If you don't think you need to get an attorney, just go to one of the courtrooms that hear foreclosures any morning and watch it happen.
Well, and then there's a new statute in Illinois that says that once you have filed an appearance or as an individual defendant appeared in court, 60 days later you lose your right to bring a standing argument. So it's really important that you know if you're going into court that there are deadlines that you have to be concerned about.
And it gets technical and it goes beyond the average.
And that's very recent legislation and very important that Erica speaks of. But you know, the public needs to know that the banks are still stacking the deck. They've now passed legislation that says that if a pro se homeowner comes into court and files an appearance and doesn't raise an objection to whether or not the plaintiff has standing in 60 days, they lose it. I have huge problems with that.
And they send letters out. They send letters out to the defendants telling them that they need to be at the status hearing. Then the case management hearing is really to see whether service has been affected.
And it would seem like the judge's hands are tied. They have no way around it because you have this statute.
Not only are they tied, you know, we have some extraordinarily fine people that sit on the bench. There's a judge in my circuit that hears 100 and 250 cases a day, the most patient man. But the truth of the matter is they do hear 250 cases a day, and it's awfully hard to get justice 4.5 seconds at a time.
One thing I want to touch on, and then we're going to have to wrap up with Erica or whoever wants to address it, is the effect on somebody's credit. and there's some myths about that. If you could quickly touch on that for me.
Well, you know that credit reporting is a closely guarded trade secret, so we don't know exactly what the impact is going to be on credit. And I've heard a lot of different information lately, but to the extent that you can avoid a foreclosure, you are going to improve your credit. To the extent that you are not going to have money sitting out there that you owe, you're going to improve your credit. So having that strategy up front about how you want to approach your life going forward, what your age is, what your future is, that's going to be critical for making a determination as to what the impact on your credit is going to be.
So as we wrap up here, each of you have been great to share your thoughts and have had just a tremendous amount of experience in this area. If you're to give our audience some piece of advice or suggestion on how to deal with this issue of foreclosure, what would it be? Samuel, I'll start with you.
Come up with an objective, and I know how difficult that is under the face of a foreclosure, and then create an environment to achieve the objective.
Erica?
Don't hide your head in the sand. Make sure that you take responsibility for the actions that you've taken so that you can come out with a good result.
And last,
make your decision with your head, not with your heart. But then remember that sometimes there are silver linings in these gray clouds. If you can, look right into the cloud.
Again, thank you for all your help, your advice, your suggestions on this very important topic of foreclosures. My name is Marty Dolan, your host for the Illinois State Bar Association Illinois Law Program. Thank you for joining us.